So welcome everyone to the Burness Paull construction webinar. We have automatically muted you when you joined the call, and if I could ask you just to make sure you remain on mute throughout, that would be helpful. This is the third in the series of COVID-focused seminars that we have run to look at the impact on the construction industry of the issues thrown up by the COVID virus. For those of you that don't know me, I'm Fenella Mason, partner in and head of the construction and projects team here at Burness Paull, and I'm chairing the session for today. I'm joined by two of my colleagues, one from the construction team, Horsley, and also by our health and safety specialist, Lynne Gray. Chris is a senior associate in our team and specializes in renewable work as well as projects work, and most of Chris's projects work at the moment is focused on the Hub initiative. Lynne is a partner in our health and safety team, and she handles contentious and non-contentious regulatory and compliance issues, helping clients in matters such as fatal accident inquiries, defending regulatory prosecutions, managing internal investigations, as well as advising on external investigations by police, HSE, SEPA and other regulators. So she's very well placed to help us take a look at health and safety implications for the industry by the virus. Before we get into the meat of the presentation, just some housekeeping matters. As I've mentioned, the mics, that would be great, keeping those on mute. As far as questions are concerned, Lynne has kindly said that she's willing to take questions during the course of her presentation. So please do raise your questions with me via the chat function, and I will put your questions to Lynne. So your questions will be anonymized. We like to do that because we record the sessions for distribution. If the recording creates any concerns for you, please do have a look at our privacy policy on our website. The session will finish by 1 o'clock. We may finish slightly earlier if you don't have many questions for us. Anyway, turning to look at the agenda that Lynne and Chris are going to cover for us today. Lynne's going to start looking at health and safety obligations for the industry, what the obligations are, and importantly, what the sanctions for breach of those obligations might be. Chris is going to take us through the latest Scottish guidance, of which there is a plethora. Interesting issue that's arising for some of our clients, payment for off-site materials, and then looking forward optimistically to preparations for remobilisation. So with that, I'm going to pass you over to Lynne, who's going to tell us a bit about health and safety obligations in the current environment.
Thanks very much, Fenella, and thank you for inviting me along today. As Fenella said, we're happy to take questions as we go through the session today. We'll try to interject them at appropriate points if anyone does have questions, and if we can't get the answer today, then I'm more than happy to get back to you after the session. My details are at the end of the materials, so feel free to follow up. It's slightly difficult in this virtual environment to have the level of interaction that we would have if we were face-to-face, but we'll certainly do our best to do that today for you and answer any questions you might have. In relation to health and safety at construction sites, the current position is unique. The Scottish Government has requested that all construction projects, other than those delivering essential, and I put that in quotes, buildings, should cease and sites close. Stronger Scottish Government guidance was issued for the construction sector a week ago, Monday, the 6th of April. And that was in sharp contrast to the UK Government advice, which says that construction sites should stay open if contractors can meet public health requirements, including social distancing and enhanced hygiene, and at the same time adhere to industry-agreed site operating procedures. And I understand that the position relating to site operating procedures is also subject to change, and that was just updated yesterday. In light of the guidance from the Scottish Government, many construction sites have chosen to close voluntarily, and that was even before the stronger Scottish Government guidance came into force, into place last a week past Monday. With no anticipated lifting of the restrictions which are currently in place, and as the situation north and south of the border remains at odds, clients increasingly are asking us for advice about the legal position where they may want to stay open or where they are considering reopening. Now, Chris is going to look at the contractual position around that and some of the implications associated with those decisions. But I've been asked today to outline the health and safety duties in relation to the pandemic and how that sits with the current restrictions in place and, in particular, the Scottish Government guidance. So, what are the implications for construction sites either staying open or reopening at the moment? Well, for anyone working on a construction site, I'm sure we can all agree that there's a requirement that the work cannot reasonably be done from home, but not every site will be carrying out what the Scottish Government regards as essential work. For any employer continuing to operate or looking to reopen a site, the Scottish guidance and the new unique coronavirus legislation introduced in response to the issues created by the pandemic must be considered alongside existing health and safety duties and legislation. From a health and safety perspective, legal risks associated with health and safety failings do exist, but could probably be regarded as low at the moment. However, reputational risks are much, much higher, and I'll come on to look at that in relation to possibilities around enforcement and what that might mean. There's no specific coronavirus legislation ordering sites to close in Scotland. At the end of March, we saw legislation passed in record time through both the UK and the Scottish Government. The Coronavirus Act 2020 gained royal assent on the 26th of March, which enabled the Scottish Government to introduce the Health Protection Coronavirus Restrictions Scotland Regulations 2020, which I'll just refer to as the regulations as I go through the talk today. And those came into force on the 27th of March, so just the day after the UK-wide legislation. The Scottish regulations contain the expected general public health protection measures to prevent, control and mitigate spread of infection or contamination in relation to people and property associated with COVID-19. In the absence of a reasonable excuse, it is now a criminal offence in Scotland for people to leave where they live as a means of enforcing social distancing in response to the coronavirus pandemic. And that's why we're all sitting remotely at home today and joining this webinar via WebEx. Construction sites or construction work are not specifically mentioned in the regulations. Accordingly, despite the guidance issued by the Scottish Government, carrying out construction work is not a criminal offence under the regulations. Closure of specific businesses was required by the regulations, and that included businesses such as cafes and restaurants, nail salons, swimming pools. And while certain businesses such as supermarkets and food suppliers can remain open subject to various special requirements in relation to both people and property, there was no specific mention of construction sites. And I should probably add there was no specific mention of legal services or lawyers either. Under the regulations, when a person leaves where they live, it's a reasonable excuse and a defence to travel to and from work where working from home is impossible. The regulations provide other examples about what may amount to a reasonable excuse, such as shopping for necessities. However, it's important to note that what may amount to a reasonable excuse is not prescriptive, and it will be a matter of discretion for the police on a case-by-case basis when they're seeking to enforce the regulations. Gatherings of more than 3 people, not from the same household, are also subject to restrictions. Failure to comply with the regulations is a criminal offence, and they apply to individuals and corporates. Police Scotland can use reasonable force to remove someone back to where they live and have the ability to issue fixed penalty notices or prohibition notices as an alternative to prosecution. But prosecution is a possibility where there have been offences under the regulations. On prosecution, the penalty is a fine up to a maximum of £10,000 per offence, Where a corporate body or partnership commits an offence and it is due to consent, connivance or neglect of a manager or a partner, that individual also commits an offence and may face a fine. The regulations do not remove the health and safety duties incumbent on any employer, including the construction industry. Employers have a legal duty to take all reasonably practicable steps to ensure the health, safety and welfare at work of all employees, and that general duty extends to protecting others affected by their work activities, including contractors and the public. And I'm sure you're all familiar with those general duties. The unique operating environment in the construction sector creates its own challenges in addressing the risks associated with the virus. And as we'll come on to see, there is a possibility of enforcement, including the possibility of requiring sites to close as a result of failures in managing the risks associated with the virus. So what does the health and safety legislative framework look like for the construction industry at this time? As I said, it's no different than normal, but this is a public health emergency. Local authorities have powers under the Public Health Scotland Act 2008 to carry out investigations, enter premises and ask questions, and have the ability to order a range of public health measures in relation to premises and things in order to prevent the spread of infectious diseases or contamination, including COVID-19. Now, those powers will be carried out through environmental health officers and will include the possibility of serving notices on the occupier or owners of premises for disinfection, disinfestation or decontamination of premises or things. But in addition, existing health and safety duties apply. So in terms of general health and safety duties, the overarching piece of legislation remains the Health and Safety at Work Act, 1974. And as I've outlined, that's where those general duties that I mentioned earlier come from, requiring all employers to ensure, as far as reasonably practical, the health and safety of employees, other workers, and members of the public affected by their work activities. The legislation is goal setting. It sets out the duties without prescribing how employers should achieve them. Various regulations, as you are aware, supplement the Health and Safety at Work Act, addressing risks, specific risks, including some which are directly relevant to the construction industry. I won't go into detail of those, but it's worth mentioning the Management of Health and Safety at Work regulations, the Work at Height regulations, LOLAR, and of course the CDM regs. There's also other primary legislation which may apply, such as the Fire Scotland Act. Breach of health and safety duties are criminal offences and can lead to criminal prosecution. In Scotland, the Crown Office and Procurator Fiscal Service determine whether any case will be prosecuted, following the matter being reported by the Health and Safety Executive. Penalties include significant financial fines and also the possibility of imprisonment for individuals. The HSE separately has the power to issue enforcement notices where they consider there have been breaches or failures in managing health and safety risks. And those enforcement notices can take the form of either improvement or prohibition notices. Now, a prohibition notice could potentially shut down part or all of a building site, and a prohibition notice could be issued when, in the opinion of an HSE inspector, an activity carried on either does involve or will involve a risk of serious injury. And that could include serious personal injury risks associated with COVID-19. Failure to comply with an enforcement notice, including a prohibition notice, is a criminal offence. Enforcement notices can be appealed. Any prohibition notice would remain in effect until any appeal was determined. To assist in complying with health and safety duties, duty holders should have recourse to relevant guidance available from the HSE and other sources, including industry bodies, and, in this case, in the time of a pandemic, the guidance which is available from the Scottish Government. The intention of guidance, as the term suggests, is to assist with compliance and offer practical or technical advice. Guidance is not compulsory unless stated. If relevant guidance is followed, it's normally enough to comply with the law, but if guidance is not followed, justification may be required as to why not, including being able to demonstrate an alternative approach that worked just as well or better.
Lynne, can you tell us what that would mean in practice for the construction industry?
Yes. I mean, as I said, Fenella, this is a public emergency. The risks associated with COVID-19 are grave, and I think we're all aware of those through the public service announcements and the restrictions that we're all currently living under and living with. For those operating construction sites, the risks to health associated with COVID-19 must be managed on an ongoing basis. The Scottish Government guidance states that Scottish construction sites should, and I would put that in big capital letters, should close, not that they must. The Scottish guidance is in fact a polite request expressing a desirable goal without directing the same. The Scottish Government stopped short of expressly requiring construction sites to close, as they have done with other businesses such as cafes, restaurants, etc. And the Scottish Government is also at odds with the guidance which has been issued by the UK Government. So each construction site will have to consider for itself if it should or should not remain open or reopen. But be alert to the fact that while current restrictions are in place, any decision that's made will be subject to scrutiny, potential challenge, and possible enforcement action. Any decisions taken may have to be justified, and that could be right up to board level, and it would be necessary to demonstrate that there are no risks of spreading the virus or contamination, and that all reasonably practicable measures have been taken to prevent and mitigate the risks associated with the virus. Excuse me, just got a bit of a dry throat there. It's not anything more sinister, I can assure you. That means that any site which is operating would require to ensure that they follow existing public health guidance in relation to preventing the spread of the virus, as well as complying with any other relevant health and safety legislation. And like any other workplace hazard, the risks posed by the virus need consideration, starting with a risk assessment. And for construction sites, the public health emergency that is the pandemic should have triggered a review of all construction phase plans and health and safety files already. Objective project and site-specific detailed risk assessments will be required to plan, prevent and mitigate the risks associated with the virus to an acceptable level. And it could require very difficult decisions to be made, because where the risks associated with the virus are grave, can you as an operator of a site ensure that there are no risks for those that you're expecting to come on and work on that site. Any risk assessment has to identify the primary health risks and extend to manage and mitigating any safety risks created by the requirements of social distancing at the moment. That can cause huge operating issues around tasks that just may not even be possible to be performed at a time when the restrictions actually still exist. It will involve the ability to implement the social distancing, cleaning, enhanced hygiene, access to toilet, canteen and other welfare facilities, consideration around transport to site, sickness policies, PPE and first aiders. Business continuity and resilience plans are key at this time. Essentially,
can I just pick up there?
Yes,
so,
sure.
In line with a lot of other health and safety issues, is it right that the key thing here is also making sure you've got the audit trail of your decision-making process?
Yes, entirely, because that is effectively would be your defence. Where you're subject to challenge, as I said, you're going to have to demonstrate that there are no risks associated with the virus, in particular around infection and spreading the virus or contamination, and having in place these reasonable practical measures. And the only way that you can do that and demonstrate that is by having an audit trail. and it's reflected in the goal-setting nature of the health and safety legislation, where it's effectively self-policing. It's requiring employers to put the measures in place, but then check that they're working, and you would have to be able to demonstrate all of that to have any success in being able to justify your position and staying open here. So yes, it's entirely right, and it would that's why your construction phase plan and health and safety files, etc., will all have to be up to date and reflecting the position regarding any risk assessments that have been conducted in relation to COVID-19. It's also necessary that, as well as having that audit trail, that you discuss and consult with your employees about the measures that are in place, so that they understand the risk assessment and the risk controls that have been put in place. You might have to conduct training associated with that, and looking optimistically ahead, sites reopening, that could mean time and resources being required to consider things like training and having the measures put in place that are needed around that. The police don't have powers at the moment to close a building site under the regulations, but they're likely to rely on their presence to persuade any operator of a site to close. And that was what we saw, certainly a theme emerging before the regulations came into force. And since the regulations have come into force, the police have upped patrols, and they are very much more present in communities and are taking action where they see any activity that could cause concern in relation to risks associated with the virus, whether that's groups of people gathering on a street, or people travelling, going about where they could have a reasonable excuse, but the police are much more visible. However, local authorities could use their power under the Public Health Scotland Act, where a principal contractor doesn't effectively implement, monitor and enforce public health guidance in relation to virus. There's the risk that the HSE will take independent enforcement action to shut sites through prohibition notices. And the audit trail that you mentioned there, Fenella, is entirely what you would need to have a defence to any challenge. If you wanted to appeal a prohibition notice, then your audit trail is effectively your defence and your challenge to any such notice. The HSE's approach is consistent with a joint statement which was issued by the HSE and the Partnership for Health Safety Scotland on the 8th of April last week. And the HSE have also confirmed RIDDOR reporting requirements in relation to coronavirus, where there are instances of possible or actual exposure to coronavirus. That's a dangerous occurrence and is required to be reported under RIDDOR. A worker that is diagnosed as having COVID-19 and where there's reasonable evidence that it was caused by exposure at work, then that also requires to be reported as a case of a disease. Although I would say that in those situations there's likely to be a plethora of other sources where somebody could be exposed. So the requirement there that there would have to be reasonable evidence is a threshold that would have to be met before it would have to be reported as a case of a disease. But where a worker dies because of occupational exposure to coronavirus, again, that needs to be reported. So, all the messaging from the HSE is that they are looking at this as something which they will consider enforcement, which would have to be proportionate to the risks presented. And they've not specifically mentioned prosecution. They've said enforcement action, including through to prohibition notices. So I think that's the more likely approach of the HSE, and any audit trail is what would be required to challenge or appeal any such enforcement.
What do you think? You've mentioned the Scottish Government guidance. What do you think are the likely consequences of failing to follow the guidance, which you've described as a polite request, which I thought was a lovely description of it? It's a polite request. What happens if you don't follow the polite request?
Yeah, I mean, Nicola Sturgeon has had to defend her position publicly about the Scottish Government guidance, but hasn't gone further to put the actual force behind the words around the polite request that the construction site should close. I think she's relying on people, as you know, the situation is the same with all of us as individuals, to effectively do the right thing. And while the current restrictions remain in place, failure to follow the Scottish Government guidance, including reopening a closed site at this time, you know, while the restrictions are still in place, at the very least will attract attention and scrutiny and could result in enforcement action, as I outlined, by either the local authorities or the HSE. And I think what's more likely is, you know, significant reputational damage that could be associated with that. It's likely that if there was enforcement action, somebody could choose to appeal that and get into a contentious litigious situation. But that could have the potential to lose reputation, given that we're all, you know, as everyone keeps saying, in this together, and everyone's expected to take a certain approach to try to prevent the risks associated with the virus. There's slightly different situations, I think, that could result for both individuals and any sort of operators of sites. For the companies, you know, I've mentioned the enforcement possibilities that are there, but if the HSE become aware of a COVID-19 related incident through RIDDOR reporting, say, just like any other incident where the reporting suggests health and safety failings and breaches of duty, the HSE would be required to investigate. If there was a trend of workers all from the same site falling ill due to the virus, it could trigger the HSE investigation, and where the spread of infection is connected to health and safety failings relating to a specific work site, then the HSE could consider enforcement action. Any enforcement action HSE, but would be proportionate to the nature of the risks, the risk created and the nature of the breach, but that could include prosecution. And it's important to note that in relation to health and safety failings, serious injury or death don't have to occur for the HSE to take action. So if people do not have to become infected or contaminated with the virus for the HSE to take action. Local authorities, their powers are slightly different, but for the HSE, all that is required is for the risk to be there for them to be able to take enforcement action. We've discussed already about the possibility of appeal and having a defence. Duty holders would require to demonstrate that they had done all that was reasonably practicable to prevent the risks associated with the virus, and would have to require to rely on risk assessments and implementations of those. Where if it was possible for the HSE to establish a causal connection between the health and safety failings and the failure to follow guidance, then that would amount to an aggravating factor in relation to any enforcement, potentially increasing the level of any fine. It's worth noting that there's, for directors, managers and senior officers of companies, under the Health and Safety at Work Act, there's the possibility of individuals being held to account and liable, where the corporate body or partnership commits a health and safety offence, and it's due to the consent, connivance and neglect of that individual, who could be a senior manager or senior officer of the company, so that would include directors, then that individual also commits an offence and may be subject to prosecution. And penalties there include not just a fine, but obviously imprisonment. And since 2008, it's been possible to sentence individuals under the health and safety legislation to up to 2 years in prison. So that's quite significant if you're thinking about making decisions around whether to reopen a site, when to reopen a site. Be conscious that it's not just the organisation that may be subject to enforcement for any perceived failings, but those who are making those decisions could be held accountable for those in line with the Health and Safety at Work Act and the powerful tool that's contained in there. The intent of those offences is to make those responsible for decision making within organisations accountable. and that could include any decision to keep a construction site open during the pandemic. And the regulators having the ability to target those accountable for decisions taken on behalf of the business is a powerful tool. A QC that I work with regularly says it's the most powerful tool in the hand of the regulator. So that, coupled with the Scottish Government guidance, is the tools that are being used here to try to affect decisions a certain way. So that's the companies and those responsible for making decisions within the company. There could be implications. There's also implications for employees, because if you don't follow the Scottish Government guidance in relation to a construction site and choose to reopen if you've closed or continue to stay open, then your employees or your contractors are having to come to work. Now, employees have got their own individual duties under the Health and Safety at Work Act to take reasonable care for their own health and safety and the people that they work with. They've got to cooperate with their employers to allow them to comply with their duties under the health and safety legislation. But Nicola Sturgeon was quite vocal in putting the onus back on employees to take action if they felt that their employers were not doing the right thing. And she mentioned that specifically in relation to some of these restrictions around businesses that she was expecting to close, effectively asking employees to stand up and take action where they felt that their employers were not acting in a safe way or ensuring their safety. I have to say it's extreme and unlikely that the HSE would seek to take enforcement action against an individual for failure of health and safety failings. Certainly the cases that I've been involved in where it's been quite clear that there have been failings on the part of an individual, the HSE and the Crown Office are very, very, very reluctant to take action against those individuals. We have had one case where an individual was prosecuted for health and safety failings under the Health and Safety at Work Act, and that case went to trial, and the jury found the individual not guilty. But that's extremely rare, and in that situation, the individual and the company were prosecuted, but the company negotiated a plea and did not go to trial in relation to the charges that they faced. Disciplinary proceedings are a much more likely scenario for any employee who refuses to cooperate, or if they recklessly risk their own health and safety or the safety of others. And the powers contained in the Scottish regulations allow Police Scotland to take action against an individual. So individuals could be stopped on their way to work and questioned about what they're doing. And they could be subject to question about that. I think it's unlikely that the police would fine someone who said that they were going to work when they couldn't work at home. But again, it's more likely to trigger scrutiny and further potential enforcement action from other areas around that rather than fining the individual. Police Scotland are more likely to approach their employer and the site and question why people are continuing to work, which could trigger further enforcement action directed at the site from either the HSE or the local authority. I sort of alluded to it at the start, but the reputational risks here are huge and should not be underestimated. I think in addition to any financial fine, and the enforcement has the potential to adversely affect the reputation of any business. And I think in this day of social media, the naming and shaming of employers by employees is much more prevalent. I was listening to the radio this morning, and there was a very well-known brand of shortbread, which is reopening next week, and the employees of that company have expressed disquiet and concern about being required to go back to work at the moment. So naming and shaming is this environment that we live in now, but I think undoubtedly reputational risks associated with this shouldn't be underestimated. And it's difficult when we have a juxtaposition between Scotland and England in relation to the guidance. But you know, running the gauntlet and challenging that could have caused reputational damage. It's just whether or not the risks are worth it, I suppose. In the time that we're living in, it's quite difficult with the current situation involving the pandemic and death rates, etc., still rising, and the restrictions still in place. It's difficult.
A couple of questions have come in for you, Lynne. The first one is, do you think that your analysis is the same for both essential and non-essential sites? So we had the Scottish Government guidance identifying 13 critical national infrastructure sites, and we certainly in the team have mulled over why is the health and safety regime any different for one or the other. So it'd be really interesting to have your views on that.
Yeah, I mean, it isn't, you know, the health and safety regime is a UK-wide piece of legislation, and the duties are the same. The difficulty that we're facing at the moment in the Scottish jurisdiction is this different guidance from the Scottish Government, and it's when you look at the tenor and the language that's used in the Scottish Government guidance, the requirement for sites to where they say they must close is where the essential sites cannot comply with the public health restrictions and other health and safety duties. Beyond that, it's the situation where, you know, they should close. It's that polite request, and the overarching requirements in relation to public health guidance and health and safety duties remain the same. But I do think that you know, in Scotland we've created a difficult position for ourselves where you know, certainly those who have businesses that they may be seeking to want to reopen around, you know, for construction sites, it's difficult decisions which, you know, you would need to be quite sure and confident and robustly being able to take a stance that you could ensure the health and safety of the people that you're expecting to come to work, because ultimately, you know, those duties remain the same regardless of what you're doing.
Yeah. Okay. And the second question is quite a technical one, and anticipating the lockdown extending, say, beyond May into June, and questions about planned and preventative maintenance regimes for plant and equipment on site. That work won't have been undertaken during the lockdown period. So is there a need to emphasise that all site plant and equipment is subject to the statutory re-examination regs, and what should be done about that? What would the employer's obligations perhaps be in relation to that regime?
Yeah, I mean, there's certainly, I think, recognition that there may require to be some relaxation around requirements relating to certain inspections, etc., of things that may need to be done, certifications. And I think, you know, the regulators acknowledge that when current restrictions remain in place, there are certain aspects of work that cannot be done. Obviously, when we're looking at getting back to some sort of semblance of normality, whatever that may be, and the restrictions being lifted, it's likely to be done in waves. But for any, you know, going back to what I said generally in relation to compliance with the duties, you know, it's assessing the risks and looking at each stage, considering the risks associated with the virus, the implications that that's had. If that means that there are certain things that have not been done or that still require to be done, then you know, some of the inspections, etc., may not have taken place, so they may need to be done before certain work could actually then take place and carry on. But all of that will be subject to risk assessment and mitigating the measures associated with that. And I think it's likely to expect further guidance or measures coming from various regulators depending on the length of time that the restrictions go on. It's unusual to see relaxation of requirements around statutory inspection, certification, etc. in these, as commonly referred to now, unprecedented times. So it's changing so quickly that everybody, I think, just needs to be constantly aware of the situation, any relevant guidance, any relevant instructions, and any risk assessments need to be dynamic and constantly reviewed and updated, particularly if you're planning ahead and looking to reopen, that any risk assessment process needs to be, inherently dynamic so that you can respond to what's going on.
Okay, thanks very much, Lynne. And I'm sorry we've not left you with very much time to cover the topics that you're going to talk to us about, but if you can have a stab at covering your topics in the 20 minutes that we've got left, that would be great.
No, absolutely, Fenella. Thanks very much, and thanks, Lynne, for that excellent coverage of health and safety factors. I'm going to talk a little bit about some of the Scottish guidance that we are currently looking at, and the picture certainly continues to develop, as has already been discussed today. The Scottish construction sector is having to comply with a fast-moving and at times inconsistent series of construction-specific guidance notes issued by Scottish Government against the backdrop of non-construction specific legislation, regulations and guidance, and all with an added layer of complexity that the Scottish Government advice is issued at different terms and at different times from the UK Government's guidance. This is certainly having the effect that the overall guidance picture is difficult to follow. So unless the intention is to drive the sector towards their legal advisors, a single document consolidating at least the Scottish position would certainly assist. And we note that in yesterday's update to the Scottish Government website, pertinent guidance has at least been collated on a single web page as a step in the right direction. We always have to be aware that whilst the guidance uses mandatory language at some points and less mandatory at others, it does remain guidance only. As Lynne has mentioned, it does not have legislative effect, and accordingly, compliance with any guidance is not a statutory requirement. The first key bit of construction sector guidance that I wanted to look at was the COVID-19 construction sector guidance that came out last week. The headline advice for the industry within these guidelines is that all non-essential businesses should close and that construction and its supply chain, except where supporting an essential sector, are to be considered as non-essential and should stop. Therefore, if the work does not fall within the given sectors, which were energy, communications, government, transport, finance, civil nuclear, defence, chemicals, space, health, food, water and waste, or emergency services, the activity should cease. The guidance also provides that even if you're working within an essential category of sector, only elements which are essential to that sector should remain open, and that should be interpreted as being elements which provide support to an aspect of the COVID-19 defence. In addition, projects that ensure facilities continue to function safely and maintain essential levels of utility are also considered essential and permitted to continue. But only essential work should take place, and where projects can safely be concluded at a later point, they should be paused. Even if a project could be viewed as essential, it can only continue if it can comply with the guidance on the safety and welfare of people, and it must comply with all of the law that's out there. And I spotted one of the questions that came out as we were going through the health and safety section. There is elements of therefore thinking about if you are supporting, for example, a supermarket in doing a construction project, this does tick the box of being in the essential sector of food. However, does the work that you're doing tick the second box of being essential work to allow that to continue in defence of the COVID situation? Certainly, refurbs of Sainsbury's Cafe will not qualify, but there'll be a huge grey area in between to be considered. Secondly, I wanted to have a little look at the two Scottish Government construction policy notes that have come out in recent days. The first one, CPN1, complements all of the Scottish procurement policy notes that 4 and 5, which came out previously. It also takes great pains to direct the reader to the specific Scottish Government website as regards general COVID and specific health issues, and directs the reader to the construction sector guidance too. So again, we have a number of other things to be aware of, and proper interpretation and application to the particular circumstances requires this policy note to be read alongside and with reference to the growing number of other pieces of guidance and law. The key messages in this CPN are that the industry must take a responsible approach to the containment of COVID-19, but remain in a position to respond to critical requirements and longer-term recovery strategies. It suggests that the construction sector's capability and capacity to effectively recommence work and deliver the current and future project pipeline should be protected wherever possible. It notes that contracting authorities should work with their suppliers to determine the impact on a project pipeline and, if works are non-essential, consider using a hold point to delay commencement after any contract awards. It suggests that agreement should be reached on any costs arising from such a delay prior to its implementation to assist suppliers to plan for and schedule the recommencement of operations. And in terms of procurement competitions and decisions, it specifically states that these should be continued to be decided on the basis of usual routes and well-known principles. Bidders' suggestions as to anticipated COVID delay to program can be something which is up for evaluation where competitions are continuing. It specifically notes that flexibility to the usual procedures for effective contract signature and corporate governance across a range of matters related to any affected contract are encouraged. Contracting authorities are encouraged to try to agree with the contractor a process for identifying and recording any prolongation and disruption directly attributable to COVID-19 to try to minimize the potential for disputes. In this regard, it suggests that open and honest dialogue about the impact of delay on the project, staffing issues, and contingency plans is shared and encouraged, as is open book justification of the relevant matters and costs being incurred. So there's a number of potentially relevant contractual provisions and key matters which we all know from looking at our individual contracts. This CPN doesn't attempt to go into any project specifics, but it does list a number of the options without material detail. It directs parties to review their contracts with the relevant advisors. The second CPN which came out, the much shorter CPN 2, that deals with project bank accounts, and it allows for alternatives to wet ink signatures. It follows on from the earlier guidance in the form of the procurement policy notes, which said similar options for sign-off of procurement documentation and relaxation of government measures should be implemented if necessary. This does not mean that any sort of electronic signature remotely is acceptable, and we're certainly concerned that some signatories may not take appropriate advice on how to ensure there's a valid signature on their document. We're very aware that the relaxation message may be taken too far, and we must try to guard against inadequate documents being signed. So please do take advice in advance of signing off any contracts. Thirdly, the Scottish Futures Trust issued some guidance on operational PPP projects, and you can find my blog on this on our website. This is for application where a project following one of the models of Scottish PPP has achieved completion of construction and has entered into the services phase. The key essence of the SFT guidance is to place a significant emphasis on the partnering relationship between the public sector authority and the private PPP contractor. The strong suggestion is that contractual wording, entitlements, and strict procedures should be regarded as low priority in the present circumstances. The SFT note that PPP contractors should regard themselves as part of the public sector response and play a key role in ensuring that vital public services can continue to be delivered during the coronavirus emergency. And whilst this noble sentiment should quite rightly be the priority at this time, we do suggest that it be crucial to the avoidance of future disputes that the parties to an operational PPP contract clearly document their agreed understandings with reference to the contractual provisions that apply. The SFT guidance includes the following key statements and recommendations. Firstly, that contractually, The COVID-19 emergency is not to be regarded as an event of force majeure or as a circumstance entitling the private sector to relief from deductions as an excusing cause under the model contracts used in PPP. Best efforts should be made by all parties to enable continuation of service provision under PPP contracts at an appropriate level of operational capacity. Both appropriate public services and payments to contractors should be maintained, and the parties should work closely together to agree any necessary revisions to the contractor requirements and standards. And where services or performance are impacted due to COVID-19, despite the best efforts of the PPP contractor, there should be a temporary moratorium on most payment and performance mechanism deductions. Now that's just the range of some of the guidance that's currently out there and three of the most pressing aspects that we wanted to cover today. I wanted to move, if I've got time, on to one live topic which we've been dealing with, which is complications surrounding materials that are being held off-site, and whether title can pass of these to the purchaser and whether payment is made. Normally, the risk could be considered quite low, as generally materials which are received by a contractor off-site would often be transported to site fairly promptly and perhaps in advance of a relevant monthly payment being made. In the current situation, the risk is much higher, and we're seeing more instances of materials being held on another party's property somewhere in the chain, and delays are much longer. All this whilst maintenance of payments to the supply chain are being encouraged. So a party may find that it's paid for materials but has not received them on site. A complication with the Scots law position, which differs from English law, is that in English law, title can transfer on payment, and there's greater flexibility in the area. In Scots law, however, delivery is absolutely fundamental to the transfer of title, and where materials are held off-site, there is no delivery. The Sales of Goods Act 1979 does allow for transfer of title in accordance with the relevant contract in Scotland, but this will apply only in relation to a pure contract for the sale of goods. And it's been established by case law that a building contract is a mixed contract and does not tick that box. This means that a separate contract of purchase which sits alongside the building contract is required. And where the parties have anticipated a period of holding off-site, then this is sometimes put into practice previously. But now, in light of unexpected COVID-19 delays, parties may wish to review their positions and may wish to try and enter into some sort of contract for purchase now, as the circumstances may have changed. If you do so, there are relatively simple forms of contract which can be provided and are available, in which payment terms need to be addressed clearly and the timing for transferred title needs to be clearly established. You should always consider, if you're entering into one of these agreements, making any key subcontractors involved in the supply of storage of these materials also a party to that document. Finally, we wanted to have a start on looking ahead to remobilisation, and certainly some of Lynne's talk picked up on the themes of this. It may be considered to be a little bit early to think about remobilisation, and certainly the government is currently taking the firm view that the focus should remain squarely on dealing with the virus at present. The concern is that discussing how the lockdown will be eased may cause people to relax their day-to-day routine and thereby undermine the lockdown measures. But contrast this with places like Spain, where construction with social distancing measures has recommenced, and with little notice of that recommencing. We must recall how quickly the government made certain decisions in relation to the lockdown. Some measures were ratcheted up with virtually no warning. And although the picture in terms of whether construction sites should have been closed has been a developing one over a number of weeks, it might be prudent to anticipate that a decision to allow sites to reopen may take the form of a next-day declaration of the government without prior indication. It's notable that yesterday the First Minister stated her intent to present the Scottish Government's thought process for easing the measures in the coming days, which will assist. Now, whether a next day or slightly longer period is available to prepare for a return to site, the effect of government declaring the sector open for business will need to be carefully considered on a case-by-case basis, and it cannot simply be assumed that the COVID-19 affected period will end from this point contractually. In the same way that specific contracts have required analysis in terms of classification of the COVID position. Parties will need to consider the other side of the coin when determining whether any contractual force majeure or extension of time period should be considered to have ended. The wording of the guidance or law which eases restrictions may be key. Is it in the form of a mandatory law, or much more likely, is it just another piece of non-binding guidance? What are the constraints applicable in that guidance in terms of distancing on sites and subsectors of the economy, etc.? Chiefly of concern to contractors should be the question of whether a site can reopen legally with a view to the health and safety duties and concerns which Lynne has been discussing. If there is uncertainty as to the safe working measures and all the concerns of staff on site, those who are first to act may well find themselves having to defend their position and their reputations. You should also take care to consider good industry practice, which few people have mentioned in the conversation. This shifts daily. What is good industry practice? And a requirement to comply with good industry practice is a feature of many contracts, particularly in things like the renewables sector. So there'll be a number of considerations beyond the government announcement which will determine whether a site can reopen. And many of those will be influenced by the planning and mitigation measures which contractors should be putting in place during the current restrictions. Many contractors who have found themselves in a position of relief under their contracts whilst the restrictions were in place may find that responsibility for any further delays will swiftly shift back to them. Questions to be addressed include whether subcontractors are ready, willing and able to return in line with the main contractor's remobilisation intent. Are staffing numbers sufficient in terms of sickness absences, furlough or similar measures having been concluded and run their course, and transport to sites having been adequately re-established? What additional measures such as social distancing need to be implemented at the site, and what training, etc. is required before you're ready to implement this? External factors such as delays in the supply of materials will need to be resolved, as will any third-party consents which involved time-sensitive commitments such as limited licenses to occupy certain areas. And it's notable in this regard that it has been confirmed that planning consents will automatically be extended to account for COVID-19 impact, which is helpful. We should also consider the controls of third parties. Does the employer have a contractual right to authorize recommencement under your contract? What about any requirement under your suite of contracts to receive a funder view? Has your insurer confirmed their position on whether a return to site at this point will be insured? Finally, we need to consider where matters stand between the parties on what has been agreed in terms of the effect of COVID-19 on the contractual obligations and entitlements. The guidance tells us that the period of lockdown should be being used by the parties to have an open and honest dialogue about the impact of the virus. Our advice has been that the communication lines between employers and contractors should be active throughout the outbreak, with evidence of impact and decisions being compiled and shared regularly in the interests of dispute avoidance. Time limits and notice requirements in the contract should be complied with, or adjustments addressed expressly and agreed. On that basis, it's reasonable to expect that the parties should have at least established, before any remobilisation, an agreed position on which contractual mechanism applies to this delay and matters such as the date on which the delay under the mechanism commenced. The parties should then look to their contracts to follow the required processes to determine any revisions to programme and the extent of any extensions of time, etc. We fully anticipate that there will be many disputes in the market about the reasons for delay and relevant entitlements. As noted yesterday in the helpful paper issued by JCT, they have said that when considering extensions of time, for example, and the quote is, because of the exceptional circumstances of coronavirus and the many possibilities of how delay might arise with problems of concurrency, a pragmatic approach may be appropriate in some situations. However, it should not be treated as an opportunity to cover all manner of other programming problems. We anticipate we may well see those words quoted in future actions, and certainly the principles of concurrent delay and the issues that arise are well known. So the key is continue the dialogue, continue in mitigation, and we will certainly see more to follow on considerations for remobilisation. And with that, I will hand you back to Fenella.
that we've run out of time. I know that there are some questions unanswered, so please do pick up with us, drop us an email. And one question we didn't get to was on frustration. We do have a good blog on frustration on our website, so please do go and have a look at that. Feel free to email any of us in the team. We'd be delighted to pick up with you on your COVID issues. So thank you very much, and hopefully be back for another webinar in not too distant future. Thanks very much. Bye for now.
Thank you. Thanks, Fenella.
Bye.